indeed.
My ladies, my lords, I appear on behalf of the Department of Justice, the respondent in this case, my learned friends Mr McLaughlin and Ms McElveen. The Department is a public authority under challenge in these proceedings,
Yes.
and we're glad to be able to make a contribution to the discussion. We have been challenged by the applicant on the basis that we should have introduced legislation permitting termination of pregnancy on grounds of fetal abnormality and in case of sexual crime. Of course, it was never in our gift as a department to grant the remedy that was sought by the appellant in these cases. This was always going to be a matter that required legislative action on the part of the Assembly. The department has never engaged, in our submission, in any unlawful act in these proceedings. Far from it, we say. We say quite properly, through the legislative process, the department has sought to introduce amendments to the law on abortion in Northern Ireland. In particular, the department has sought to explore the possibility of amendments in respect of fatal fetal abnormality. It also consulted on the possibility of bringing definition to questions of serious fetal abnormality, and it consulted on questions of the possibility of bringing forward legislative amendments in respect of sexual crime. So the very issues that the appellant brings before this court are the issues which this department was grappling with. And indeed, the application commenced during the course of the first consultation exercise conducted by the department. The department did not engage in this process of potential law reform because it was compelled to do so by the Convention. And this is a point of difference, important difference between us. The department's analysis was that there was a public interest and a public policy issue in play that required the law in Northern Ireland to be considered for the possibility of reform. The department did not consider that there was a Convention imperative to change the law. And it may well be that there was some commonality in terms of overall possible outcome, but the department did not accept that it was required by the Strasbourg jurisprudence to take the steps that it was considering taking in the course of this exercise. Indeed, when the Commission engaged with the department in 2013 in respect of the possibility of law reform, the Commission itself was somewhat more equivocal than it is now about whether or not there were Convention imperatives actually in play. The Commission's line in 2013 was to the effect that there may be breaches of Article 8 or there may be breaches of Article 3. That position has hardened considerably. The submissions this court has heard in recent days are of an entirely different character. The contention is that there is now a mandatory imperative driven by breaches of Article 8 and Article 3. The Department's position in policy formation did not accept that analysis in 2013, 2014, and does not accept it before this court. Indeed, the Northern Ireland Court of Appeal have agreed with the Department's position that there is not an imperative based on Article 3 or Article 8 to change the law. We were successful in our appeal to overturn the judgment of Mr Justice Horner, and the court's provisions on the issue are there for consideration. So our stance has been to carefully evaluate the questions that arise from the Convention, consider the issues that have been raised, and the Department's stance remains that there may well be sound public policy reasons for addressing the law in this area. There may well be sound public policy reasons for amending the law, but it is wrong to say that is driven by the Convention. And we say that analysis is supported, for example, by the judgment of the Grand Chamber in A, B and C, which of course was a decision of the Grand Chamber addressing the 1861 Offence Against the Person Act, sections 58 and 59, the same provisions that are under consideration in this case. And that court, we say, did not come to the conclusions advanced by the Human Rights Commission in this case that there was an obligation to bring forward legislative provision because of Articles 8 and Article 3. In fact, the Grand Chamber was clear in respect of Article 8. The court noted that Article 8 cannot be interpreted as conferring a right to abortion. And I'll take you in due course to some provisions of that legislation. Now, my ladies, my lord, I want to address, in the time available to me, three broad themes. I want to address the issue of policy formation in Northern Ireland and bring the court up to date as to where the matter now stands, because this has been and continues to be an evolving picture. Secondly, I want to give the court the department's submissions in respect of Articles 2, 8 and Article 3 in that order. And thirdly, I want to address the question of whether or not, if this court considers that there is, contrary to our other submissions, a convention imperative in play, the court should proceed to make a declaration of incompatibility in this context. I'll describe that as the institutional competence question, and I will take the court to a consideration of Ree, Nicklinson and Ulla. Firstly, in relation to the question of policy formation, this litigation has been running for 2 years now, and in that period there has been an ongoing exercise by the department of its policy function. The consultation that went out to the public addressed questions of fatal fetal abnormality, serious abnormality and sexual crime. I'll deal with sexual crime first. My Lord Wilson posed a question yesterday to my learned friend Ms. Leven as to whether or not she was perhaps brushing under the carpet too readily the difficulties that can arise in terms of defining and framing a law based on sexual crime. There's good reason to ask that question, and the department have asked that question in their consultation exercise. And I can show you very briefly, if the court can take up Core Volume 2 and go to the consultation document, which begins at MS 9328.
Sorry, reference?
MS 9328.
Thank you.
I'm going to take you specifically to the...
Where do we find the title page of this document?
Sorry.
And its date?
It's at 9295.
9295.
Sorry.
So it must have been dated sometime in 2014?
Yes.
Before the proceedings were begun?
The consultation document was issued before the proceedings began, and then the judicial review interrupted or came while the consultation process was ongoing. The point I'm on, my ladies and lords, is in respect of the difficulties in framing a law in respect of sexual crime, and that's addressed in the consultation document in Chapter 6, and particularly if I could draw your attention to MS 9332, you will see at paragraph 616, the department poses a series of questions about the challenges that are faced, how it could in fact be achieved, whether one would need complaints to the police, time-limited complaints, police reports, so on and so forth. Those questions were all posed. They were addressed in the actual consultation response document. The response document is of interest. It went out to public consultation, came back, and you'll find the response in Core Volume 4. The MS reference is 10042. And that's dated April 2015. The responses from the public are summarised at 10222 following. So there are a range of responses on the difficulties in respect of framing a law, and those are set out. Those who support a change in the law identified difficulties as well as those who opposed a change in the law. and they can be found between pages 10222, 10226. And the position that the Department came to at that stage in respect of the sexual crime consultation can be found at MS 10229, paragraph 9181. The Department's view was that the complexities of the issues are such it's not possible to make detailed proposals at this time on whether and how the law might be reformed specifically to cover cases where a woman's pregnant resulting from a sexual crime. Many of the original questions set out in the consultation paper remain to be resolved before policy proposals can be formulated. The Department will consider further, but does not intend to bring forward legislative proposals in relation to Part 2 in this Assembly mandate. The Department considered the sexual crime issue to be too difficult to frame in terms of, at that stage, a legislative amendment. Now, in exchanges yesterday, the position taken by the appellant is that addressing a law in respect of rape or sexual crime is doable. The examples that are referred to are, for example, Germany and some other European countries, which of course operate on a different legislative model. In those countries, access to abortion is based on gestational time limits. So up to a certain period of time, a person can seek a termination of pregnancy on request without the need to identify a specific or fall into a specific category. That's not the model that we operate in Northern Ireland. It's not necessarily the model that's operated in the United Kingdom. So the question of whether or not it's doable does require some contextual analysis. In the Northern Ireland context, the view of the Department was, at this moment, this is a rather difficult challenge. That, of course, was picked up in our Court of Appeal by Lord Justice Gillen in his judgment, clearly recognised the force of that analysis and identified that there were proper difficulties in framing a law in respect of sexual crime. That said, after the original judgment in this case, the Northern Ireland Assembly was called upon to consider an amendment to the law in order to address the cases of pregnancy arising as a result of rape. And there were particular amendments brought forward in the Assembly in February 2016 to address this issue. And I can show you those. Again, goes to the question of what is or is not doable in this context. You will see it at Core Volume 3, MS 9779.
Dr. McGleenan, you say correctly that the Assembly considered this after Mr. Justice Horner's judgment. I couldn't quite identify the date of your notice of appeal, but I suspect that it was before the Assembly debate.
I think it's likely that it was.
Yes.
The decision was in December of that year. I think our notice of appeal would have predated the February.
Very well.
Now, the document I'm showing you at 9779 is a proposed amendment brought forward by one of the Northern Ireland Assembly members, Ms. Lowe, to introduce a clause to the 1861 Offence Against the Person Act, making provision for termination of pregnancy on grounds of rape or sexual crime. And I'm not going to take the court through the detail of that, but you can see that within it there are potential difficulties, definitional difficulties, difficulties as to whose responsibility it is to take certain courses of action, difficulties of assessing contraindications, and how the matters may in fact play into any ongoing criminal prosecutorial process. So, doability, we say, cannot be assessed in the abstract. The Northern Ireland Assembly has considered a proposed amendment exactly on the point and has rejected it. So, we say that is not necessarily the end of the matter. The Department of Justice have indicated that they continue to consider the issue. They did not bring forward that amendment because they did not have executive approval to bring forward any amendment. But that policy formation process is not necessarily at an end.
Well, how does, to use your expression, doability sound on the question of whether there has been a violation or whether there is incompatibility with the provision?
Well, we say there isn't any of that, but what it may well go to is questions, if we get to the stage of accepting that there is a convention breach, whether or not this court should make a declaration of incompatibility or should engage in any other intrusive form of action. So that's what it goes to.
We don't need to be concerned about doability in examining whether there is incompatibility.
Not necessarily, my Lord. It goes to the later stage question of what it's appropriate for this court to do. But when I'm sketching these points in terms of bringing the court up to date on where the policy sits, but it very much feeds into the Nicholson type analysis.
Isn't doability an element of proportionality insofar as you're looking to see whether there is some appropriate means of dealing with the matter?
Yes, it factors into that analysis, certainly. And I'll come back to that when I get to the Nicholson points, my lords, my ladies. So, in respect of fatal fetal abnormality, which is the other limb of the analysis, again, that is not a static situation. You have, I think, before you Core Volume 3, and if you go to pages MS 9780, you will see here statements on behalf of the First Minister's, at that time's political party, the Health Minister, and also relating to the Department of Justice, indicating the establishment of a fatal fetal abnormality working group. So the matter has gone back to a cross-departmental working group. Again, that's not insignificant because one of the impediments to making legislative progress in Northern Ireland is achieving cross-party approval. And if you have two departments tied into a working group process, reporting back to their ministers on a particular issue, that enhances the likelihood of achieving some change. So the fatal fetal abnormality issue has gone on to a working group. It's addressed in our second affidavit. That working group has concluded its internal workings and has recommendations ready to go to Northern Ireland ministers whenever they take up their posts in the event that there is a restoration of devolution, which we await. So the fatal fetal abnormality process has continued. The working group will recommend changes to the law in Northern Ireland, and it will be a matter for ministers as to whether or not they take those forward. So here too, we say this is not a static policy process.
Can I ask, forgive me if this is an ignorant question, but is there necessarily a hiatus until devolution is restored?
Yes, these decisions will be subject to executive approval because they're potentially controversial and cross-cutting. So there will be a need for ministerial input in order to progress those matters.
That is, if devolution is restored.
Yes.
Yes.
Well, we're all...
I think that my Lord may be interested to learn what happens if it becomes clear that devolution is not going to be restored.
Yes, I was asking because presumably at the moment there is a legislature competent to legislate for Northern Ireland, and presumably there is a government of Northern Ireland being carried on by the Secretary of State.
No, not carried on by the Secretary of State, no. Carried on currently by the senior civil servants. In the event that there's a complete collapse of devolution, the functions of the departments will be transferred by order in council to Whitehall ministers, and we will proceed under their direction and control. So the policy process in the event of collapse of devolution doesn't necessarily stop, nor does it stop at the moment because there are no ministers there, but we cannot move forward on some particular proposals until ministers are back in post. But the point is, in terms of the working group addressing this issue, its task has been to prepare the material to deliver to ministers. We are at that position. So we say that's significant. Similarly, my ladies, my lords, we say that the policy position in respect of guidance has changed importantly. My learned friend, Ms. Leaven, opened to you she describes the 2013 guidance document yesterday, which you have in Core Volume 2 at, I think, MS 8934. And there was some confusion yesterday about the status of this document. This document was draft guidance issued for consultation purposes. My learned friend drew attention to a number of paragraphs yesterday. I'll just flag them for you. 1.3, which referred to very strict and narrow criteria in Northern Ireland, in limited circumstances which termination may be lawful. She referred you to 2.8 in respect of the risks that apply in relation to a possible termination of pregnancy. And she referred you to paragraph 3.6, which referred to the cases where the prognosis leading to termination of pregnancy will be very rare. Now, the language of that document might fairly be described as austere in places, and I think the point was being made by the Human Rights Commission that this guidance document may well be contributing to a chilling effect in Northern Ireland. Now, whether that's a fair observation or not, this is not, in fact, the operative guidance document. This was a draft that was issued in 2013 for public consultation. It was the subject of strong representations by clinicians and by others, and we have a 2016 guidance document which is different both in character, content and tone. And you will find that at Core Volume 3, page 9805. And the court can, at its convenience, peruse the document in full, but what I can say is the paragraphs that have been highlighted by the Human Rights Commission, which I've suggested may well have an austere ring to them, do not appear in this document. It is not framed in that way, and there are, we say, significant additional elements to it. The paradigm for this document is directed towards the provision of proper clinical assessment for women. You will see at MS 9813, there is a section dealing with the rights of a pregnant woman to a full clinical assessment. There is a right described in Section 5, MS 9820, to advice and psychological support. That includes, you will see in bold, that it's not unlawful to inform a woman of services available in other jurisdictions. And there's detailed discussion of what clinicians should be advising women about. And I draw your attention to paragraph 513, MS 9822, where those clinicians and others are told that it will be lawful to advise women they're free to travel to other jurisdictions for the purpose of ascertaining whether it be lawful to have their pregnancy terminated there, and if so, securing that termination. So that guidance document, which is the operative guidance document, is, we say, significantly different. Indeed, I think there was a flashing reference to it today in the amnesty submissions. If you have page 9824, there's a question raised about the whether doctors are required to provide medical information to police officers on request. Part of it was read to you, paragraph 6.1, second part wasn't, that social care professionals need not give information if they have reasonable excuse for not doing so in the discharge of their professional duties of confidentiality. So some of the issues that are being passed before the court, suggestive of very exacting, harsh environment, we say must be read actually in light of the position that is adopted by the public authorities in Northern Ireland. And of course, we have allied to that the provision that there is now to be public funding for some women who wish to travel outside of Northern Ireland to access termination services in England and Wales. So we say that the policy environment has evolved even during the course of this litigation. This is not a static situation. And it has evolved in a way, we say, which serves to undermine any case that in fact there is an Article 3 or an Article 8 breach taking place. I want to deal then with the Department's position on the Convention arguments, dealing first with Article 2. And our position here, I think, has been caricatured somewhat. It has been suggested that we are arguing for some freestanding right to life for the fetus pursuant to Article 2. We do not make that case. We argue for no more than what the Strasbourg Court contends for in the Vaux case. Our submission is that because the Strasbourg Court has made no definitive ruling on the scope of the Article 2 right in respect of the unborn child, it's not possible to conclude that there are no right-to-life interests in play. One simply cannot reach that conclusion. And we draw attention to the Vaux judgment, and the Court will see, as it analyses the other Strasbourg cases that are in play here, that Vaux is a resonant theme before the Grand Chamber and indeed in the Polish cases. If the Court could take up Authorities Volume 4 for a moment. I'll go to this because Mr. Chamberlain didn't have the opportunity to go to it. You will find it tab 26, MS 1335. And the Court's treatment of the issue, you may have highlighted some of this yesterday, can be found from paragraphs 75 through to 86. Just highlight some aspects of it. Paragraph 75, the Court is yet to determine the issue of the beginning of everyone's right to life within the meaning of this provision, and whether
Page number, please.
Sorry?
Page number, please.
I'm sorry, MS 1366.
Thank you.
So, the Court hasn't made a determination on right to life in respect of the unborn. Refer you to paragraph 80, that's MS 1369. So, the third sentence, the Convention institutions have not ruled out the possibility that in certain circumstances safeguards may be extended to the unborn child. 82, there's a reference on the same page. Article 2 has been informed by a clear desire to strike a balance. The Convention institutes position in relation to the legal, medical, philosophical, ethical, or religious dimensions of defining the human being as taken into account various approaches to the matter at national level. And then at 85, that's 1371. Having regard to the foregoing, the Court is convinced it's neither desirable or even possible as matters stands to answer in the abstract the question whether the unborn child is a person for the purpose of Article 2 of the Convention. Now, what that amounts to, ultimately, we say, is that when one comes to address questions of balance in the Article 8 context, one cannot come to the conclusion that there is nothing to weigh against the balance in terms of the autonomy of the mother. Because the fetus, whatever value it has, and the Court has not been definitive about it, cannot be said to have no value in Convention terms. Therefore, there is something in play. And the value that's to be ascribed to it is a matter that is within the margin of appreciation of the individual states. So, our position is not that there is any Article 2 right to life in the fetus, not that at all. It is simply consonant with the reasoning of the Strasbourg Court in Vaux that there is something there of intrinsic value that requires to be weighed in the Article 8 balance. And we say this is what, in fact, explains the decision of the Grand Chamber in A, B, and C. The appellant says A, B, and C has to be understood in terms of the Court's analysis of the profound moral views of the Irish people. That's what is different about the Republic of Ireland. We say no. A proper reading of that judgment shows that what was really influential for the Court was the Vaux question and the fact that there is some intrinsic value to be attributed to the fetus. It cannot be ignored. So the position we take in respect of Article 2 feeds into the position that's taken in respect of Article 8. On the Article 8 case, I deal with that fairly briefly before turning to A, B, and C. The submissions that were made yesterday by Ms. Rose in respect of the autonomy of the pregnant woman, again, we, on behalf of the Department, take no issue with that. We recognise that the autonomy of the pregnant woman can be in play. In fact, we have accepted in our case that in these situations there may well be Article 8 engagement and Article 8 interference. So autonomy is in play. The question is, ultimately, whether or not there is anything to counterbalance that on a Convention analysis. And we say here, again, the A, B, and C judgment of the Grand Chamber is on point. You'll find that at Authorities Volume 3, MS 814, tab 13. We've been criticised for saying that the Grand Chamber was deciding a legal framework that was conceptually identical to the Northern Ireland legal framework. Let me explain why we say that it's conceptually identical. It's conceptually identical because in the Republic of Ireland, termination of pregnancy is subject to the 1861 Offences Against the Person Act. Exactly the same provisions. It's a pre-partition statute that applies north and south. The only difference was that in the Republic of Ireland, the Eighth Amendment to the Constitution made a more exacting provision in terms of respecting the unborn child. So the common law statutory framework is exactly the same north and south. That's why we say this case has a very strong resonance for the matter that is ultimately before your lordships. Now, I don't have time to take the court through all of this judgment. It's a nuanced decision, but I wanted to highlight some aspects of it. If I could invite you to turn to MS page 873, you will see paragraph 222, where the Grand Chamber was considering whether the interference, that was the prohibitions on accessing termination of pregnancy, pursued a legitimate aim. And in the analysis of legitimate aim, what the court sees in the middle of that paragraph is the Vaux point. So it's not just about the morals of the Irish people. You'll see in the middle of the paragraph, the impugned restriction was found to pursue a legitimate aim for the protection of morals.
Sorry, please forgive me, I didn't make a proper note of your page reference.
873, madam.
873?
MS 873 of Core Volume, Authorities Volume, 3. Authorities 3. So the legitimate aim in Ireland was protection of morals, of which the protection of the right to life of the unborn was one aspect. That was confirmed in the court's finding in the above-cited Vaux and France case. So Vaux and France was clearly influential in the legitimate aim analysis. You'll see the same theme picked up at paragraph 237, page MS 876, where the Grand Chamber said, of central importance in the analysis is the finding of the above-cited Vaux case, that the question of when the right to life begins comes within the state's margin of appreciation because there was no European consensus on the scientific and legal definition of the beginning of life. It's impossible to answer that question. So while it is right that the court was considering the profound moral views of the Irish people, expressed as they were in referenda at that time, those profound moral views also chimed with the Strasbourg court's analysis in Vaux. The two are intertwined. So it's not simply the case that one looks for profound moral views as expressed in a referendum. The issue of the Article 2 Vaux factor is static in all of these cases, regardless of referenda or opinion polls. The position is different in Article 8 terms when a member state of the Council of Europe actively legislates in order to make provision for termination of pregnancy. At that stage, the balance is different. The state will have expressed its view on where the interests of the fetus lie, and the court will take a different position. That's illustrated by the Polish cases. If I could refer you to RR, which is at Authorities Volume 4, tab 22. You will see at MS 1225 the court's treatment of the Vaux issue and Article 8 in paragraphs 186 and 187. The position changes whenever a state actively legislates for termination of pregnancy in its own domestic law. At that juncture, the approach the Strasbourg Court has taken is to conduct an exacting examination in Article 8 cases to see whether or not the state, while having made provision for termination of pregnancy, has in fact put impediments and obstacles in the way of women accessing those clinical services. And that is the recurring theme of the Polish cases. The court has made findings of Article 8 breach, not because there was no law, but because a law had been enacted, yet impediments were being placed in the way of those who wanted to access it. It's an entirely different situation from that which we are considering presently. So we say the Article 2 vote analysis is critical to the Article 8 examination. What we say ultimately is when the court's considering Article 8, what's relevant in the Northern Ireland context is we have not positively legislated, as the Polish have done. It is a margin of appreciation matter. It is correct that there is maternal autonomy engaged, but that it must be balanced against some value to fetal life.
But where is maternal autonomy reflected in the existing law?
The existing law, in certain circumstances, will allow for a termination of pregnancy, in extreme circumstances. Now, that will be a born type...
That's maternal ill health I'm talking about, and you were talking about, very realistically, maternal autonomy. Where is that reflected in the existing law?
Existing law, as I've outlined in respect of the guidance, makes provision, essentially, for access to termination of pregnancy in other jurisdictions of the United Kingdom. That's not necessarily an entirely satisfactory answer.
That leads to the question, the profound moral view of the Northern Irish people. Does it detract from that profound moral view for you advocates to be saying, well, they can go to England?
Well, it doesn't undermine the validity of that moral view. The moral view is one that's been recognised as being legitimate by the Strasbourg Court. The question ultimately is, are we in the territory of any convention breach because of that provision? And we say the steadiest guide to that is the Strasbourg Court itself. Has the Strasbourg Court found in any parallel position that there is in fact a convention breach in terms of Article 3 or Article 8? The answer to that, in our submission, is no.
What does personal autonomy mean in this context?
Autonomy in this context means the ability to make informed decisions about healthcare and pregnancy, ultimately.
Well, is that not under the existing law in Northern Ireland heavily circumscribed, to say the least?
Lord, I don't depart from that. One of the reasons why the Department has endeavoured to reform the law is in order to expand the categories, make provision more available. But the Department operates in a constitutional and political reality.
Yes, well, I'm not seeking to even appear to be critical of a department, and one can readily recognise the dilemma in which it finds itself placed. But addressing the question at a theoretical level, has there been, as my Lord Wilson asked you, is there any true recognition of personal autonomy in the case of pregnant women under the existing state of the law?
Well, there will inevitably be the hard cases when the assertion of autonomy runs into the prohibitions that the law arises. In all other cases, there won't be any conflict in terms of maternal autonomy. So you will, until you run into the difficulties in the Bourne test, have no impediment on autonomy. But in that context, when you do, we reach a difficulty. That we, the Department, have recognised. We have also recognised that there may be public policy reasons to change that. The issue for this court is whether or not there's a convention imperative to change it. And we say, on that point, Strasbourg does not take us there. My Lord, the new guidelines, we say, do change the context. They operate in a different paradigm. They suggest appropriate provision of advice, counselling and social care, and they inform people of the options that are available to them. The austerity that may have been there previously is no longer in play at public policy level.
Well, it still reminds practitioners of their duty under the Criminal Law Act of 1967, if they have reason to suppose that an offence under the 1861, 1925, isn't it, Act 45 Acts have been committed, to report it.
Yes. Accept that.
And that obviously had an effect in one of the examples that we have before us today, but it must have had an effect in other cases too. Is a woman ever going to tell?
I can't give an empirical answer to that question, but equally there's nothing legally inaccurate about the way in which the law is stated in that guidance document.
No, but it gives the impression that people will be prosecuted if they don't pass the information on. In fact, it says that.
Well, there's a qualification to it in the
Yes.
paragraph that I think I highlighted, 6.1. It suggests that that may well be overridden by professional confidentiality duties.
Well, not.
No.
Look at the last sentence.
No.
No bar to reporting offences to the police.
Yeah, and there's a duty under. I've just been looking it up.
Well,
So,
that is an expression of the law, I'm afraid.
well, I suspect the law is the same under the Criminal Law Act 1967 in the rest of the United Kingdom. But I'm not aware of any professional guidance. If it's not, I'd like to be told.
I'm very confident it's not, my lady, but we'll check that.
Fair on that point.
Well, I'm not sure there'd be any professional guidance going out to healthcare professionals saying, if you have reason to suspect that an illegal abortion has taken place, you must report it to the police. But if there's no equivalent provision, then
Well, I don't want to-
my problem goes away. So
It does. But of
let us
course-
find out the answer to that first.
The legal paradigm is also different, of course. The 1967 Act creates an entirely different
Oh,
environment.
but there still are illegal abortions.
Yes, exactly.
I suppose, I mean, the way the court approached the matter in A, B, and C was to say that you had to strike a balance between the women's right to respect for their private lives on the one hand, and the moral values of the Irish people on the other hand, and in holding that the balance had been struck in a way that fell within the margin of appreciation. Obviously, they were dealing with a law which didn't attach any significance to women's autonomy. It's the same law as we're dealing with in this case. But that's where they said they had regard to the fact that it was perfectly lawful for the women to travel abroad and had access to appropriate information and medical care.
Yes.
So the autonomy point was really answered by the availability, but by the lawfulness and availability of procedures for those who wanted them elsewhere.
And of course, that had been a contested issue in the Republic of Ireland for many years. There had been previous litigation about whether or not you could, in fact, provide information about right to travel. Indeed, the X case was about preventing someone from travelling to the United Kingdom for the purpose of determination. So this had been clearly a matter of some considerable dispute. That having been resolved, the Grand Chamber took comfort from that position.
Yes, it was paragraph 241 that I was looking at.
Lords, my ladies, I want to deal very briefly, if I can, with Article 3. Mr. Chamberlain has dealt with that very fully. Our points on this I can summarise. In terms of the negative obligation, the Strasbourg Court has not spoken with one voice in respect of Article 3. There are cases where the Strasbourg Court has found no breach of Article 3 in challenging factual situations. One example will be A, B and C, which is a case of non-provision of an abortion law. The paragraphs I'll give you are paragraphs 160 to 165. The Article 3 claim was considered to be manifestly ill-founded. The Polish case of Tysiak, reference volume 4, tab 25, MS 1297. I don't have time to open it to you, but the relevant paragraphs are at 67 and 68. A very extreme factual situation, a woman who's likely to lose her sight if her pregnancy continued. Pregnancy was ran to term. She was not allowed to have a termination in Poland, even though it was lawful, and she lost her eyesight. Despite the harrowing factual situation, the European Court found no breach of Article 3. On the other hand, you have cases such as R&R and P&S, also Polish cases, where the court found that there was a breach of Article 3. Now, our point about it is this. There is no clear and consistent line of Strasbourg authority on the negative obligation as to whether or not Article 3 is breached by non-provision of a law permitting termination of pregnancy. No clear and consistent line of authority. The authorities point in different directions, reacting to the specific facts of individual cases. We also submit that the Article 3 assessment is always fact and context specific. It is suggested here by the Human Rights Commission that one can evade that stricture by saying you can occasionally look to questions of systemic risk. And if you identify a systemic risk, then that would allow us to reach a generalised conclusion about Article 3 breach. We say that's not a sound proposition, even in the types of cases that are relied upon, such as refoulement cases or indeed extradition cases. The courts will always consider each case with a specific eye to the circumstances and facts that actually apply. So it still remains a factual specific analysis, even in cases of risk. So we don't need to put it any higher than the fact that there is no clear and consistent line of Strasbourg authority. There's certainly no case which says non-provision in the three categories identified by the Human Rights Commission results in a breach of Article 3. And that I will feed that into our submission on the ULA point in a moment. On the positive obligation case, we say similarly, we're not dealing here with an absolute position in any event. We adopt the submissions that have been made on behalf of the Attorney General in respect of the need for treatment. I would highlight to the court the Strasbourg decision in Pretty in the United Kingdom, which can be found at Volume 4, MS 1174. That is tab 22. And I wanted to highlight to the court the analysis of the treatment issue that appears in paragraph 54. That's on page 1174. Where it was considered that the claim in that case placed this is on page 1175, fifth line, is a new and extended construction of the concept of treatment, which goes beyond the ordinary meaning of the word. While the court must take a dynamic and flexible approach to the interpretation of the Convention, any interpretation must also accord with the fundamental objectives of the Convention and its coherence as a system of human rights protection. Then we note, and this goes to a point Lord Mance raised yesterday, Article 3 must be construed in harmony with Article 2, hitherto associated with reflecting basic values respected by democratic societies. So in the positive obligation cases where we're not dealing with absolutes, the Article 2 right to life interests can also be factored in to the Article 3 assessment. My Lord Mance was asking yesterday, is Article 2 and fetal life irrelevant in an Article 3 case? We say where one's dealing with a positive obligation, it's not irrelevant. I do not purport to say what it is to be weighed as, but it is a matter to be properly considered. And that's what the Strasbourg Court found in Pretty in the United Kingdom. So, my ladies and lords, we say there is no clear and consistent line of Strasbourg authority on the Article 3 and Article 8 points advanced by the Human Rights Commission. Turning to my third topic, the question of what the court should do if the court considers that it should go beyond where the Strasbourg jurisprudence sits, or if it thinks that the Strasbourg jurisprudence currently impels a conclusion contrary to that I've outlined. We say the starting point here should be the approach of the Supreme Court in Rabone, and you'll find the authority at volume 10 of the authorities, tab 94, and the passage I'm going to refer the court to is in paragraph 112, which is at 3575. And I do this because the appellant says we, the department, have a simplistic view of the other principle. We don't characterise it correctly. We say this captures what really is in play here. And the question we say, as set out by Lord Brown, is whether or not the conclusion that there's a need for a reform of the law is clearly compelled by the Strasbourg jurisprudence. Paragraph 112, halfway through, what the other principle establishes, the domestic court should not feel driven on convention grounds unwillingly to decide a case against a public authority because it cannot have a corrective judgment, unless the existing Strasbourg case law clearly compels this. So we say that's the threshold this court is looking for. Does the Strasbourg jurisprudence clearly compel a different conclusion than that for which we contend? Now, I say...
Well, you've considered statements by, among others, my Lord Wilson in Muhan on this question.
Yes, my Lord. You're asking if I've considered those?
Yes.
I'm not sure that I have them
Oh,
in
I
hand,
see.
my Lord, but no doubt the court can reflect that on any ultimate analysis. But, if it undermines the submission I have or if it endorses it.
I think I charted the movement away from Ulla in about 8 different cases over the years since then.
Well,
And even in this paragraph, I mean, Lord Simon Brown says clearly compelled, but then goes on to say that the domestic court may be content, perhaps even ready and willing, to decide a convention challenge against a public authority and believes such a conclusion to flow naturally from existing Strasbourg case law, even though it might be seen as taking it a step further. So he's not, I mean, that's not a clearly compelled by existing case law. That is what is the natural development of the existing principles, which is what we did in Rabone. It was quite a bold decision, in fact. Just turned out that we were right, but we might not have been.
well, I don't want to spend too long on the building blocks. I can move to the position that I need to get to here, which is, our position is there isn't anything that clearly compels a conclusion here, but we are in territory, I accept, of margin of appreciation. Moving quickly to the end point, if we're in territory of margin of appreciation, we're in Re-G, Nicholson type territory. The question is, in that context, should the court take the next step and move beyond what the Strasbourg jurisprudence currently says? So I can leave the foundations to one side, move to what is the high watermark of the argument advanced against me by the appellant, which is, we say, Re-G. The appellant says, this is a Re-G type situation. The Strasbourg court may or may not have said what's required here, but this court, faced with what it's faced with, can take the next step. Now, our position in respect of that is the comparison with Re-G is not a happy one. Re-G is, we say, properly to be considered an exceptional case. Indeed, that was the view expressed by the Court of Appeal in Nicholson whenever it came to consider Re-G. I need to give you the take it to the citation, but it's addressed by Lord Dyson, MS 452, paragraph 110. They note that the Re-G was an example, thus far the only example, and was wholly exceptional and far removed from the Nicholson case. What was happening in Re-G was an objectively irrational rule preventing people who were not married from adopting a child who had lived with them in a family unit for a decade. And the court quite readily found that was something that required to be addressed. Now, that was a case also involving secondary legislation, and no question of a declaration of incompatibility. In fact, the declaration made by the court was sufficient to effect a change in practice in Northern Ireland immediately. So there was no need to go that far. Here we're dealing, we say, with something rather different. Here we're dealing with primary legislation, the 1861 Offences Against the Person Act. We're dealing with a situation where there is not objectively such obvious irrationality because there are competing worldviews about what is the correct way to deal with termination of pregnancy. And we're also dealing with a situation that is not so readily amenable to remedy. A simple declaration by a court will not necessarily address the complexities of termination in respect of sexual crime or fatal fetal abnormality. It cannot be done at the stroke of a pen. Indeed, it would be reckless to do it at the stroke of a pen, we say. So Re-G, we say, is the high watermark. It is not a proper analogue with this case. And the better analogue would be the analysis of the court in respect of Nicholson, where again there are some helpful pointers as to how one ought to approach a situation of this type.
Why couldn't a simple declaration in this type of case work? It would throw the matter back more clearly to the legislature.
Yes, Lord. The difficulty with this is another dimension to this case, which I think we need to grapple with. We're dealing here with a matter that is properly devolved to the Northern Ireland administration. In other types of cases like Nicholson, the matter would go back to Parliament, so we go straight back to Parliament. Here, that doesn't happen because it's a devolved matter, may go back to the Northern Ireland Assembly, who may or may not act upon it, but public authorities, the DPP, doctors and others will have to react to whatever this court says. And if this court simply says the law's incompatible, what's the next move? What are we meant to do in practice with that?
Well, the law remains in force until something is done about it. That's right. Notwithstanding a declaration of incompatibility.
Yeah, the law is enforced, my Lord, yes, but this goes to a point my Lord Wilson grappled with in Nicholson, which was to the effect that if the court's going to take that step, it must first of all clearly identify, surgically identify what the incompatibility is and identify what the remedial action would be. And we say that's the sort of exercise that would be essential in this context. So if the court was going to make a declaration of incompatibility, it would need to, with surgical precision, identify what the problem was and take the next step, which is to suggest remedial action, because it is a matter of obvious complexity. What that actually points towards, again, is back.
That can't invariably be the case, as I observed yesterday. They didn't do that in Bellinger.
No.
Which is a very good example of the need for a new legislative scheme, if there is incompatibility. That's, of course, the big if in this question. And the very reason why they did make a declaration of incompatibility, despite the fact that Parliament had got, was almost on the case, was to reinforce the need for Parliament to do something. But they didn't say what Parliament had to do, very far from it.
I accept that, but keeping our feet on the ground in respect of this, let's say, for the sake of argument, this court makes a declaration of incompatibility, and let's say that the Northern Ireland Assembly doesn't exist or does nothing, Parliament does nothing. Public authorities tomorrow have to make a decision compliant with the Convention. This court will have said, what you were thinking of doing is not compliant with the Convention. The question will be...
No, they'd be required by primary law to act as in accordance with the current law.
Yes, they'd be protected by Section 6 of the Human Rights Act.
Well, these are arguments, I say, in favour of reticence on the part of the court in terms of making a declaration of incompatibility, because we say, in line with the analysis in Nicholson, this is the sort of territory that is better left to whatever legislature is available to deal with it. That's the point we ultimately get to. And here we rely, in particular, on Lord Neuberger's analysis. You'll find this in Volume 2 of the Authorities. MS 452 is the first judgment in that bundle. Sorry. I wanted to take the court, in the interest of time, directly to Lord Neuberger's analysis at 116.
In our judgment rather than the Court of Appeal, is that right? That must be right.
This is in Volume 2, MS page number 516. This goes to institutional appropriateness of the court dealing with the matter. And a number of pointers are raised here. First question, whether the provisions should be modified raises a difficult, controversial and sensitive issue with moral and religious dimensions, which justify a relatively cautious approach. We would say that applies here. Secondly, is a reference to cases where the incompatibility is simple to identify and simple to cure. We say that we're not a REG type situation. It isn't simple to identify nor simple to cure. And thirdly, whether the matter has been subject to parliamentary debate in recent times. We say again, in this case, the court can see that this very issue was a subject of debate in the Assembly in February 2016, and there is ongoing policy formation. Add to that, we say, there is an important additional factor, which is the need to be considerate of the devolved nature of this function. This is a situation where the law in Northern Ireland is different from the law elsewhere in the United Kingdom. There's an argument for levelling the position up on behalf of the Human Rights Commission. But the devolved nature of the function, we say, is significant, and we reflect here some observations of my Lord Reid in Bank Mellet, which are quoted actually in the same judgment at page 532, MS 532. This is quoted by Lord Mance, actually, where in Bank Mellet, paragraph 75, to allow the legislature margin of appreciation is also essential if a federal system such as that of Canada or a devolved system such as that of the United Kingdom is to work, since a strict application of a least restrictive means which only allows one legislative response to an objective involves limiting protective right. It is relevant, we say, that this matter has been devolved to the Northern Ireland institutions. We say, rather than pushing this on the basis that there is a convention imperative to change the law, there are hard yards to be made by Northern Ireland lawmakers. There is compromise and consensus to be reached. That's best achieved through the democratic process, the legislative process, rather than suggesting, wrongly in our submission, that there is some convention-based shortcut. We don't differ in some respects from the appellant's analysis that there's a need for a change in the law. We differ on whether or not the convention absolutely requires it. And we have one eye on other social policy issues in Northern Ireland where similar arguments can be mustered. We say that the question of whether or not the convention really requires these changes must be subject to exacting consideration. And in our submission, the case is not made out. The opinion should be.
We say the case is not made out. What is the comparison we should be making, or is there not a comparison we should be making? The existing law allows abortion in certain circumstances, are being born circumstances, but it's a precondition of that any damage to mental health should be long-term as well as serious. But is it legitimate to ask oneself, well, here we're concerned with short-term torment, as it's been put, either through having to bear for 8 or so, or 7 or 8 months, a fetus which is not going to survive, or having to bear for that period a fetus which is the result of rape, and then live for the rest of your life, which is a pretty long-term event. I mean, just take, I've ignored serious fetal abnormality for the moment, for simplicity, but just take the latter case. Couldn't that be said really to be comparable in seriousness to what is already allowed to inflict? And yet, in the born-type case, the fetus takes subordinate place. Why doesn't it take subordinate place in a situation where the mother is going to suffer a whole lifetime of knowing that she's having to devote herself? She probably loved the child very much in the end, but nonetheless, it's a total agony for a long time, I imagine, if not the whole life.
This is the very issue that I think that exercised the Lord Chief Justice in the Court of Appeal. There was a lively debate in the Court of Appeal about whether or not the way forward in this may well be to reinterpret the Bourne exception in a way that took a different view of longevity of suffering and impact. And clearly the Lord Chief Justice was inclined to take that view. That the other 2 members of the court didn't support that analysis. We're not sure that that is, in fact, the correct approach in all of this.
I can see that, but I'm not sure my question goes so much to that. I mean, that's one way out of the question, but it may just be relevant also to the question of incompatibility. Is there a distinction which can really rationally be maintained between the seriousness of the 2 situations? If the fetus takes subordinate place in one, why not in the other?
I'm not sure that I can articulate a rational distinction for that, but what the Strasbourg court's been tolerant of is having distinctions based on considerations that aren't really amenable to objective empirical analysis, giving a value to life that...
Trouble is, if you give it a value in one situation, but in a parallel situation which is not rationally distinguishable, you don't, then perhaps it undermines the law in relation to the former situation?
See the analysis, my Lord. I'm not sure I can answer it anyway.
Well, perhaps you should be let off the hook of answering that, as you're 5 minutes past your time in any event.
Oh.
But that's not your fault.
No.
So,
Grateful. Those are our submissions.
thank you very much indeed.
My ladies, my lords, for coherence, I'm going to structure this reply around Mr. Chamberlain's 6 points and then pick up other points made by the attorney and Dr. McGleenan separately. Because although Mr. Chamberlain was, in theory, addressing Article 3, many of the submissions he made, in truth, went to all three of the issues before the court. In my submission, the starting point in reply is that Mr. Chamberlain started, for the purposes of Article 3, in completely the wrong place, and his submissions were truly remarkable for their absence of reference under Article 3 to the impact of these provisions on women and girls. It can only appear from his submissions that there is no dispute that the evidence shows, to use the words of Pretty, the case he places such reliance on, that there is a real risk of intense physical or mental suffering by reason of the inability of the women and girls to get abortions in Northern Ireland. That is the Pretty test, intense physical or mental suffering. And none of the advocates you've heard on the other side of this case have disputed one iota of that evidence of the intensity of suffering. So, turning to Mr. Chamberlain's 6 points, the first was that the law in Northern Ireland reflects an appropriate balance between the interests of women and the interests of the fetus. And he started by challenging Miss Rose's submissions yesterday on personal autonomy. In my submission, and I think this echoes a question from Lord Wilson, the Northern Irish abortion law gives no weight to women's personal autonomy. Because what Mr. Chamberlain has done is confused weight given to a woman's life, which it does, to weight given to personal autonomy. The two things aren't the same. That's why you have Article 2 and Article 8. There is no consideration given to personal autonomy in the sense described by this court in Montgomery and the cases that Miss Rose was referring to yesterday. What Northern Irish abortion law does is adopt the Bourne test, which does give weight, thankfully, to women's right to life. Staying under Mr. Chamberlain's first heading, he made extensive submissions in limited time to the political debate in Northern Ireland. And there's no doubt there's been political debate in Northern Ireland about this issue. But in my submission, that's just irrelevant to Article 3. And I would ask, I know that the court struggles with the comparison, but in my submission it is a valid one. If it was right that political debate was relevant to whether there was an Article 3 breach, then that would have been an issue in cases such as A, the terrorism case post 9/11 and the restrictive regime that was introduced there. Political debate has nothing to say to whether there is a breach of Article 3. As far as the political situation in Northern Ireland on this issue, or where it's got to, is concerned, and this is a point that the attorney, I think, came back to as well. Can I refer the court, I'm not going to go to it, to Miss Patterson, who is the civil servant responsible for these matters, or was. Her second witness statement, Core Volume 3, page 996, MS 9768, at paragraph 4 to 9, she goes through step by step what has happened in Northern Ireland in respect of the consideration of these matters. up to the judgment of Mr. Justice Horner, and after the judgment up to the Court of Appeal. As far as the working group report is concerned, if I can just again give the Court the references, the amnesty submissions, Core Volume 5, 4th Intervenor, page 18, MS 10463, paragraph 65, and it is in my submission of some relevance that working group report was produced to the ministers, it appears, in November 2016. So 2 or 3 months, we don't know the exact date, before the Assembly collapsed. But nothing was brought forward. And I would also, just while on this topic, like to remind the Court of the statement made by the previous leader of the DUP, Mr. Robinson, that the department's proposals were, I quote, doomed. And that's Core Volume 2, page 518, paragraph 7, MS 9292. I wanted to deal with that comprehensively at that point, but in my submission, none of that goes to whether there's an Article 3 breach. So moving on to Mr. Chamberlain's second point, he was seeking to rebut my submission that the availability of funded abortion in Britain undermined the reliance on the rights of the fetus. Can I say that the reliance, Mr. Chamberlain's frequent use of the emphasis of the availability of funded abortion was a mite opportunistic, given that availability only arose yesterday. But in any event, the point I've always taken in this case is not whether the funding or unfunding, but the point that the evidence suggests that very large proportion of the women who are pregnant, women and girls, do indeed travel. So Mr. Chamberlain's submission is that abortion abroad is irrelevant, and he relies on the analogy with the fact that people who are terminally ill can lawfully, from the whole of the United Kingdom, go inter alia to Switzerland for assisted suicide. In my submission, his attempt to make abortion rights, particularly for these 3 categories, analogous with assisted dying, is completely misconceived, for reasons that anyone who has read Nicklinson, Conway, or Pretty can readily understand. The issues that arise in practice, rather than in the most abstract legal philosophy, are totally different. Doesn't bear any evidential scrutiny. First of all, it appears, if one many of this court were in Nicklinson, and so it will know far more than I, but the numbers of people going to Switzerland proportionate to the class who would be affected by the case, if the case succeeded, is very small. And what that shows is that the cohort that's being protected by the Supreme Court, rightly or wrongly, depending on one's moral perspective, but that cohort is being actively protected by the upholding of the existing Suicide Act law. In other words, to put it colloquially, there are lots and lots of people who might be perceived to be vulnerable to potentially fall into the change of law that's being sought in Nicklinson and now Conway, but who are being protected and who have no prospect and are not going to go to Switzerland. Contrast that, so we've got the whole class potentially of depends how the line is drawn in the Nicklinson-Conway line of litigation, but potentially a very large class of elderly and or terminally ill people. Contrast Northern Irish abortion law, which the evidence unequivocally shows does not protect the vast, vast majority of fetuses, even if you think they should be protected. So the analysis just totally breaks down on the evidence and the facts. And even if one's going to ignore reality and get into legal purity, it still doesn't work, because the real and critical point is that the people being protected by the Suicide Act are live human beings. And that engages the sanctity of human life within the perception of the vast majority of people in the United Kingdom, people within the Western tradition. They're not fetuses, and they're certainly not groups of cells. So to try to say that one area of the law is analogous to the other, in my submission, utterly ignores the reality of the situation. Third of Mr. Chamberlain's points, treatment, and his attempt to draw a bright line between negative and positive obligations. Now, for these purposes, can I ask the court to take up both versions, or both judgments in Pretty, both the House of Lords, which is in Volume 9, tab 82, and the Grand Chamber decision, which is in Volume 4. And having asked you to do that, I'm now going to fail to find them.
Sorry, wait
First,
reference again, sorry.
Oh, I'm so sorry. So Volume 9, tab 82, MS 3212. That's the passage I'm going to take you to. The first page is 3196.
You know that this issue was considered by the court in the ABC case. And
I do, yes.
And it was, they proceeded on the basis that it was a negative obligation.
Yes, yes. I do know that. I just wanted to start by what Lord Bingham actually said in Pretty. Sorry, yes, so paragraph 14 in the speech of Lord Bingham, which is MS 3212. He's referring to the judgment in D in the United Kingdom, which is the AIDS case. And then towards the bottom of the paragraph, he says, the proposed deportation could fairly be regarded as treatment. An analogy might be found in the present case if a public official had forbidden the provision to Mrs. Pretty of pain-killing or palliative drugs. In my submission, the evidence that the court has heard is that the women and girls in these cases have been denied the medical treatment they both need and want. And when I say medical treatment, I include mental health services, counselling for somebody like JR 76. So this case falls directly into what Lord Bingham would have seen as falling within Article 3. And before we look at exactly what the Strasbourg case said, in my submission, the word to target here is need. Under existing UK law, it's the judgment of Parliament and the courts that it's in the interests of people such as Mrs. Pretty not to allow them to to have assisted suicide. So there is an argument about what they need fundamentally. Is it in their interest to allow that? And is it in the interests of the class? It cannot be seriously argued on the facts of these cases, the cases that the court has before it here, that it is not in the interests of these women and girls to allow them abortions. And that's the critical distinction. They need, within the meaning of Pretty, that medical service and the things that follow. And so if we take up Pretty in Strasbourg, which is volume 4, tab 21, And the key paragraphs, which the court's already looked at, 51 through 54, what the court's focusing on there, particularly in 51, is the circumstances in which the state has a positive obligation to provide protection against inhuman or degrading treatment. Now, before I come to the submissions as to why this case isn't simply about or merely about positive obligations but is also about negative obligations, can I just remind the court that certainly in the context of Article 8, that distinction, and of course I'm thinking of the judgments in Quila, that distinction has been broken down. And in my submission, this case may be a good example of why trying to draw a bright line between negative and positive doesn't actually stand up to very good scrutiny. But in my submission, this case isn't primarily about a positive obligation to provide protection within the meaning of paragraph 51. It's about a negative obligation on the state not to inflict or exacerbate suffering. If the court reaches the conclusion that the Northern Irish authorities here are inflicting or exacerbating suffering, then that's a breach of a negative obligation. And in testing that, I would ask the court to consider the facts of JR 76. That vulnerable girl, her suffering from being pregnant has been massively, unbelievably exacerbated by the fact that her mother is being prosecuted by the state. That isn't a positive obligation to be nice to her. It's a negative obligation not to prosecute her mother when she seeks the medical care she needs. Ashley Topley's suffering. Yes, it starts from a naturally occurring illness, like Pretty, paragraph 52. But again, it's been massively exacerbated by the state saying to her doctors, you will be guilty of a serious criminal offence if you give her an abortion. That's not a positive obligation on the state to do something. It's a negative obligation on them not to threaten her medical practitioners with criminal prosecution if they give her the treatment she wants. That's not positive, that's negative. The Northern Irish state isn't sitting here with its arms crossed saying do what you want, but just don't do it here. It's threatening, actively threatening, it's not even threatening in the case of JR 76, anybody who helps these women to get what they need with criminalisation. So in my submission, Mr. Chamberlain's, A, the differentiation is a pretty shaky one at the best of times, but B, on the facts of what's actually happening in these cases, the primary concern is a negative obligation and not a positive one, breach of a negative obligation. Fourth heading, whether inhuman and degrading treatment. Now, Mr. Chamberlain emphasises, as have the other counsel on behalf of the various respondents, the moral characterisation of the act. And this is where the Polish cases come into play, because the argument goes, well, in Poland they were breaching their law, so there was a moral imperative, as it were, on the state to help, which it breached. That isn't the case in Northern Ireland. Can I ask the court, happily it's the same bundle, to look at RR, which is in Authorities Bundle 4, tab 22, MS12, the passage I want to look at is MS1219. So this is a passage the court, I'm afraid, has already looked at, paragraph 151. Purpose of such treatment is a factor.
Sorry.
I'm so sorry.
Sorry, Ms. Leatham, could you do the rest?
Para 151, my lord. It's 1080 in the hard copy. So although the purpose of such treatment is a factor in whether it was intended to humiliate or debase, that doesn't inevitably lead to a finding of no violation. In my submission, the key words in this paragraph are the last ones. Courts found violations of that provision in many cases where the authorities dealt with requests to provide information of crucial importance, for example, about the whereabouts of their missing relatives, disclosing a callous disregard for their vulnerability and distress. I would ask the court to ask itself whether the Northern Irish state has shown a callous disregard for the vulnerability of Ashley Topley and JR 76, let alone a child victim of rape or incest. And in respect of the other Polish case where a breach of Article 3 was found, P and S, which is, I think it's in Volume 3, but I'm afraid you're going to have to give me a moment. Yes, Volume 3, Tab 20, MS 1100. And the court will remember the facts of P and S. This was the girl who'd been raped and was driven from literally pillar to post around Poland and threatened with prosecution for unlawful intercourse before eventually managing to get an abortion. Now, Mr. Chamberlain seeks to distinguish that case because he says, well, there is no analogue in Northern Ireland of the Polish behaviour. It's not shabby or debasing. And he points to the fact that as the court does in P&S, that the girl was threatened with prosecution. I would ask the court to ask itself, how different is the treatment of the state in Northern Ireland? If the girl in Northern Ireland takes an early medical abortion pill, she is at real risk of criminal prosecution, CJR 76. What is different from P&S? Different criminal prosecution, but you're still at risk of it. It's still not the state in any sense considering your vulnerability and treating you with anything other than callous disregard. And actually, in my submission, the position is worse in Northern Ireland than in Poland. At least in Poland, the child victim of rape could, in the end, get the abortion. The child victim of rape in Northern Ireland can't.
The consequence of this submission is what? That across Europe, in all countries which don't recognise abortion in the categories, their courts ought all to conclude that Article 3 applies.
Yes, in the three categories, my lord.
Yes.
That is the inevitable consequence of my submission. And that is the position of the United Nations Human Rights Committee and the CEDAW Committee and the United Nations Committee on the Rights of the Child. Those rights...
It's perhaps slightly odd that the Strasbourg court hasn't recognised that.
Well, my lord, it's interesting your lordship says that. That's one of... yes, that's the next point. Mr. Chamberlain's next point. He says, Strasbourg has never found a breach of Article 3 where abortion was denied, where there's a substantive legal prohibition. Well, there's a really simple answer to that, my lord. Strasbourg's never been asked. Where the issue has arisen, it's arisen in Poland, where that has precisely been, where that issue hasn't arisen, because Poland makes provision for these categories. There is not a single case where a victim of rape has gone to Strasbourg, or somebody with a severe fetal abnormality, and said, actually, I've got a right to an abortion here. There isn't a Strasbourg case on that point. If there was, we probably wouldn't be here. But it's little short of ludicrous for Mr. Chamberlain to say Strasbourg's never found a breach in those circumstances. It hasn't arisen. And it hasn't arisen because, well, for two reasons. One is Northern Ireland and the Republic are the absolute outliers in this situation. We've got the micro-states, which I referred to in opening, and we've got Malta. But apart from that, everyone else in the Council of Europe gives a right to abortion in these circumstances. And don't ask a little judicial common sense. If you live in Andorra and you've been raped and you need an abortion, it's not going to be too difficult to get across the border to Spain. So it just hasn't arisen. The other reason it hasn't arisen is that it's very unfortunate that when the ABC case was put together, it didn't include a victim of rape or somebody with severe fetal abnormality. But I hope that the court can understand how extraordinarily difficult it would be for a woman or girl who'd been raped to bring this kind of litigation. And the answer, so that's the simple answer to point 5, hasn't arisen. But also the substantive answer, and this was a source of some deeply ironic amusement before Mr. Justice Horner, to put it frankly, rape is an additional factor. You can't rely on ABC to say, well, she suffered considerably, some of the women suffered considerably, so you extrapolate that to rape and severe fetal abnormality cases. The critical point is that rape or pregnancy for severe abnormality put those women and girls into a different class from the women in ABC. And of course it might be the case that other women or girls, not in our 3 classes, cross the Article 3 threshold. But in my submission, Mr. Chamberlain's submission that fact, that somebody else might also be in breach of Article 3, somehow undermines my case, is logically incoherent. Because how can the fact that some say JR 76, who strictly speaking doesn't fall within our case, yes, she might have an Article 3 case, she might take it to Strasbourg, but that helps me, it doesn't hinder me, it doesn't detract from the case that in these 3 particular circumstances, rape, incest and serious fetal abnormality, it is highly likely that those women and girls will suffer intense physical and mental suffering because of these provisions. And then the last of Mr. Chamberlain's 6 points, the international material. And as I understood his argument, it went, Neulinger was a case about a specific international situation, which was the Hague Convention. Therefore, the principles in Neulinger don't apply where you're not alleging a specific international duty. Now, unfortunately, I haven't written the reference, but I think Mr. Chamberlain is probably right, and the family lawyers amongst the court will pick up the point if one looks at the facts of Neulinger. Here we are. It's bundle 2, tab... Oh, sorry. No, it's bundle 13, tab 120. And it's quite right. It was a case about the Hague Convention and about a child being sent to Israel under that convention. But the point that Mr. Chamberlain takes from that case is, in my submission, entirely wrong. And the easiest way to see that is to take up another of the cases we cite for the same point, which is Oppus. Oppus is bundle 13, tab 123, MS 4620.
Could you give me the reference to Neulinger again, please?
Neulinger was 13, tab 120.
Thank you.
And Oppus is 13, 123.
Thank you.
And if... So if the court would go to Oppus at paragraph 185, this is the case I did refer to in opening. It's a case about domestic violence in Turkey, and the wife's mother ended up being murdered by the abusive husband. And if case was brought under a number of different articles, but including, one can see at MS 4617, a breach of Article 14. And there was, the Turkish government said at 180, the government averred there was no gender discrimination since the violence in question was mutual, and went on to say this wasn't discrimination. And at 185, what the Strasbourg court did was interpret the meaning of Article 14, in that particular case, the definition and scope of discrimination, by reference to CEDAW. So they say, in this connection, when considering the definition and scope of discrimination against women, in addition to the more general meaning of discrimination as determined in its case law, the court has had regard to the provisions of more specialised legal instruments and the decisions of international legal bodies on the question of violence against women. So the court doesn't just use CEDAW and the CEDAW Committee's views, and you can see reference to the CEDAW Committee's views at 187, and the Commission on Human Rights views at 188. It doesn't just use it in circumstances where it is being alleged there is an actionable breach, such as in Newlinger. It also uses it to interpret the convention rights. Ultimately, the point comes back to the same one as in Newlinger. There is plainly a benefit in having a consistent interpretation of these terms. But the suggestion that the Newlinger principle can be narrowed to applicability only where it's being alleged that there's an actionable breach under a particular convention is, in my submission, plainly wrong. And the other point that comes out of Oppers in that paragraph is that the Strasbourg court don't just rely on the terms of the convention, they rely on the views of the international bodies. And here we have the views of the UN Human Rights Committee in the clearest possible terms in Whelan and Mellett. And that then shows as well why Mr. Chamberlain's reliance on ABC and saying, well, the court in ABC took the same material on board, as I explained to this court in opening, that simply isn't right, because ABC did not have the decisions in Whelan and Mellett, nor did it have some of the concluding observations in question here. So in my submission, the international material here is exceedingly powerful, if not actually overwhelming. Interestingly, none of the respondents' counsel picked up the challenge I put in opening, which is there is not a single case that apparently anybody amongst the copious counsel involved in this case have been able to show where this court or Strasbourg have departed from international law to the degree that would be necessary to uphold the respondent's case here. While we're on the international law material, can I pick up, Mr. Chamberlain made fleeting reference and then the attorney more detailed reference to the UN CRPD. Can I ask the court to take up our reply, which is in core volume 1, which is where we deal with this. It's core volume 1, the reply is at the end of the bundle. It's MS 8756.
(875).
8756 is the page, my lord.
Yes.
Paragraph 36. And this, in my submission, is the absolute answer to the reliance on the UN CRPD. The attorney also argues the UN CRPD is EU law because it's been designated as one of the EU treaties for the purposes of the European Communities Act. He ignores, however, the fact that the provisions of that convention are not, as regards their content, provisions that are sufficiently unconditional and precise, and they therefore do not have direct effect in a European Union law, ZVA, and that's in the bundle. Interestingly, he failed to respond to that point in his submissions. But then we go on to explain in that reply, if I can ask the court to read the entirety of that, paragraphs 31 to 39, where we explain why, in any event, the court should not place reliance on that convention. Can I then turn to discrete points made by the attorney first of all, just to pick them up briefly? Now, the attorney's point, which is, I'm sure the court will have spotted, very different from that of the Department of Justice on Article 8 and on the balance, is that it is the attorney's case that a child, even for an unborn child, even for a very short-term life, has a value of life, and I quote, the same as any other child. That was his submission. So you have a woman diagnosed with fatal fetal abnormality. The obstetrician probably, in some cases, will know with certainty that that fetus is not going to be born alive, but in some cases there is always the possibility of the unexpected happening and it surviving for a few hours or a few days. And the attorney's case, his position is that that child has the same value of life as any other child or any other person. Now, my ladies, my lords, I don't have either time or the intellectual scope to engage with the moral philosophy involved, but in my submission it is extremely difficult to accept that the life of a fetus that is likely to be born dead, but might survive for a few days, has the same weight in law as the child in Gefgen. And the critical point for this court's consideration is that the extremity of that view, doubtless honestly held by the attorney, is wholly out of step with the views of the majority of the population in Northern Ireland. And we have the clearest possible evidence of that. And it is again telling that none of the counsel on behalf of the respondents have chosen to engage with that evidence at all. There is no dispute before this court that the Northern Irish Life and Times survey information gives the best evidence of the views of the Northern Irish population, and those views are massively out of step with the views being advanced by the respondents in this case, in particular the views of the attorney. Next point is the attorney, under the heading of no more than necessary in the Bank-Mellet tests.
Is that what? I mean, that's an interesting question. That assumes that we're not a representative democracy in Northern Ireland. It assumes that you can treat it as if they've had a referendum, have elected for some different method of governing themselves.
No, my lord, I don't think I would put it like that. What it asks is that the court understands and appreciates the limitations of representative democracy. It is obviously the case that people in Northern Ireland do not vote simply, or probably at all, except a few, on the basis of the views on abortion. And this court, that's why this court has a role in protecting convention rights. It's fundamental to the constitutional role of this court. Take capital punishment. Quite a lot of evidence that lots and lots of people support capital punishment. That wouldn't change the views of this court. This court has to make its own decision on these difficult moral issues. And in some cases, it may be appropriate to say, like Nicholson, that the views of Parliament reflect, never perfectly, but reflect the views of the population. But what the court has to grapple with here, and this is where I would have to admit we haven't found a case on
But the views of the population, the majority, are sometimes not given effect in circumstances which you would probably support, for example, in relation to capital punishment.
Absolutely.
At certain times.
The point I'm trying to make is that the role has to ultimately fall on the court, and the court can't simply say representative democracy is the answer. And we certainly have failed to find any cases directly on that point. But where the court, as here, has evidence of a stark difference between the approach taken certainly publicly by Assembly members. There is that evidence of Audrey Simpson that private polling suggests private views are different, but the court can't do anything with that. The public position of the MLAs, as opposed to the really very solid evidence on the views of the Northern Irish population, the court cannot simply say, should not say, well, the Northern Irish representative body has expressed its view. Then, my lord, no more than necessary, and Bank Mellet, the attorney made the submission that, a surprising one I would suggest for somebody in his position, that despite what it says on the face of the statute, the court would never, no criminal court would ever impose life imprisonment. Well, first of all, I do rhetorically ask whether the mother in JR 76 would be quite so confident of that. Secondly, I would refer the court to the guidance. I've only got the reference for the 2013 guidance, but I think the same point comes out in 2016, which continues to refer in guidance to the doctors to the fact that the statute provides for life imprisonment. And that's in the 2013, I think I may have a reference a bit later, 2013 guidance, MS 8942. CV, Core Volume 2, 168. And I think the most important thing about the life imprisonment provision is the chilling effect it obviously has on doctors. Because whether or not they think that maybe if they got in front of the Crown Court, they might have the good happiness to have somebody equivalent of Mr. Justice McNaughton. As one of the doctors said to, I think it was Ashley Topley, I'm not going to risk life imprisonment for you. And then finally, I think on the attorney's submissions, he right at the end suggested that even if the fetus didn't have an Article 2 right, it fell within the ambit of Article 2 and therefore Article 14. That submission came as somewhat of a surprise because I've certainly never seen it written down or expressed before. But perhaps more importantly, there is not a shred of authority for that proposition. There is no case where the court has taken that approach. So, and then picking up both the attorney and I think, particularly the attorney, but I think Dr. McGleenan may have touched on this as well. In respect of Article 14, the attorney said one has to look for relevant comparability and Article 14 simply doesn't bite in these circumstances. In my submission, with all respect, the attorney is simply wrong on that. As I explained in opening, web and email in the EU context, Volume 15, Tab 138, MS 5206 at paragraph 24 makes it clear that for pregnancy discrimination in EU law, you don't need a comparator. But in any event, in my submission, the way the case is advanced by the attorney is wrong on convention law, and the case law isn't in the bundles. Enough case law in the bundles as there is. But can I ask the court to refer back to Baroness Hale's speech in AL Serbia at paragraph 23, where her ladyship explains why convention discrimination law is different and does not require a direct comparator. It may also be worth the court, I'm not going to take you through it now, looking at the dissenting opinion in ABC, because the dissenters make the strong point that the approach to Article Article 8 is a very unusual one in that case. So it makes for an interesting read. So turning then to any remaining points from Dr. McGleenan that I haven't already picked up in the submissions. Policy formulation. A large part of his submissions here seem to be, well, it's too difficult to do, too difficult to frame. So apparently the court should leave it to the Northern Irish authorities to come forward with some solution in the fullness of time, but when that would be is unknown. In my submission, that argument isn't sustainable because even in respect of sex crime, he made the point, well, it doesn't really arise in the rest of Europe because Germany, and I think he was referring to Denmark, have a different model. Effectively, you can have an abortion up to 12 weeks. And so I think the point he was trying to make was that they're criminal, that the provisions about rape and incest don't really bite. But that is not the case in Poland. Poland only allows abortion, as is clear from that appendix to Mr. Allenby's witness statement, only allows abortion on the grounds of serious fetal abnormality and sexual crime. And they have devised a scheme, albeit a scheme with difficulties, they have devised a scheme to meet those requirements. And the reference is Core Volume 2, MS 9219.
Well, there seem to be quite a lot of legal systems which use concepts which could clearly give rise to argument, including, actually, the German one, because it has a qualification for unlawful acts committed and causing the pregnancy.
And the law does have to deal with situations where people may argue. It does rather go with the territory. Mr. McGleenan then moved on to the 2016 guidance, and he tried to suggest that the evidence of what he called the rather austere guidance in 2013 that I referred to, which I think he suggested might suggest a harsh and exacting environment, was now gone in the 2016 guidance. I would ask the court, when considering what the environment in Northern Ireland is like for women and girls who find themselves in this situation, not to look at the words of any guidance, but to look at the facts of Ashley Topley, Sarah Hewitt, Denise Phelan and JR 76. They show the reality of what happens in Northern Ireland. They show that doctors will not give abortions, and the statistics show that abortions have fallen strongly in recent years, legal abortions, doubtless because of the chilling effect. Doctors will not give abortions even to women such as Denise Phelan, and that mothers and girls in the position of JR 76 are being prosecuted. That's the best evidence. And then in respect of Article 2, Dr. McGleenan suggested that the North and the Republic of Ireland were in the same position for the purposes of ABC in terms of protection of the fetus. In my submission, that's plainly wrong. Fetus has constitutional protection in the Republic, and there is all the evidence of those two referendum and the Lisbon Treaty provision. And in respect of the approach to Article 2, in my submission, it is important for the court to consider that if the submissions being advanced before you today were correct, then they would probably have led to RR and PS being decided the other way, certainly if the fetus had a right to life. But even if the fetus had some kind of halfway right to life, some interest under Article 2, that would have to have been a major factor in those cases. Each TISIAC, PNS and RR, it's clear from the head notes, the courts were referred to VO, and indeed in each case they are referred to in the judgments. In none of those cases did the Strasbourg court take the view that the fetus had Article 2 rights, let alone that anything to do with the fetus outweighed the impact on the woman and the girl. And then I think that almost finally, risk of Article 3 breach and the court's approach to the risk of breach. I don't want to go back to those Article 3 cases, but I would just ask the court to have regard to the line of cases around Wright and the Secretary of State for Health, a judgment that my Lady Hale may remember, which is Bundle 10, tab 86, and it's Lady Hale's speech at paragraph 22, and Lord Justice Dyson, as he then was, at paragraph 88 in tab 87, and I'll get Mr. Blundell to find me the MS references, because those were Article 6 and Article 8 cases, but the reason they're important was the approach the court takes to whether to make a declaration of incompatibility when a scheme or a system gives rise to a risk of breach. And some of this court may also, I'm afraid I haven't checked the personnel, may remember the recent Unison case, and Miss Rose tells me there was extensive discussion in that case about the line of cases around refugee legal action, legal centre, and detention action, again round not having to prove that every single person in the cohort or every single person affected by the scheme would have a breach of their convention rights. But I think the way it was put in Refugee Legal Centre was there a proven risk of injustice which infects the scheme as a whole. So that's another way of approaching the same kind of issue around risk. And finally, what should the court do? Institutional competence. I think the court, this court, is probably ahead of me on all these submissions. Dr. McGleenan referred to Rabboni, paragraph 112. It's very clear there that what Lord Brown was talking about was circumstances where the court was being unwillingly forced to reach a particular view by Strasbourg. In my submission, that's not likely to be the case here, and Muhan is not in the bundle. But I'm sure all members of this court will be very familiar with the facts. And so finally, what happens next? And Lord Mance's questions to Dr. McGleenan. In my submission, with respect to his lordship is entirely right. What this court should do is make the declaration of incompatibility sought. The matter then goes back to the political process. It is not straightforward in Northern Ireland at the moment what the process is, but it goes back to somebody to go to the next stage and to draw up some of the detailed consequences of that declaration of incompatibility. But the fact that there is complexity in that next stage should not in any sense stop the court from making the declaration. And yes, did you find the MS reference for Wright? No, did you?
Yeah. Sticky.
Oh, here we are, sorry. Wright, MS 3332. And the very last thing I should do on behalf of Miss Quinlivan is, you'll remember that Miss Quinlivan made the point that, took a point on in accordance with law, and that the provisions in the Northern Irish law were insufficiently certain. And there is a passage in a case which is quoted in the Family Planning Association case, which she wanted me to draw your attention to. It's Core Bundle 1, Authorities Bundle 1, Tab 1, and MS 66. And it's a reference at paragraph 55 to a judgment of Lord Justice McDermott in an earlier case where he draws specific attention to the uncertainty in the Northern Irish Act. And what he says is, he said, speaking of the equivalent English law before the Abortion Act 1967, and the Infant Life Preservation Act. Lord Diplock, in the Royal College of Nursing case, described the state of the law as unsatisfactory and uncertain. That continues to be the position in Northern Ireland, a position which, in the best interest of not only the medical and legal professionals, but more importantly of the public at large, ought to be remedied. And she wanted me to draw that point to your attention. My ladies, my lords, on time. Those are my submissions, unless I can help the court with anything else.
No, thank you very much indeed, Ms. Leven. We've been greatly assisted by everybody today, and we shall look forward to resuming the hearing at 10:30 tomorrow morning. Court is now adjourned.